Good morning. This is your Kelso Report for Monday, September 26th, and I'm your host, Clark Kelso. Well, the decade-old war against terror seems to be winding down. On Friday, in Al-Haramain Islamic Foundation versus Department of Treasury, the Ninth Circuit dealt with one small slice of that war, involving efforts by the Treasury Department to freeze the assets of organizations with terrorist connections. The court kept its analysis and conclusion focused just on the case before it, but in the case before it, found that the freeze of an Oregon organization's assets without ultimately securing a warrant violated the Fourth Amendment, and that content-based restrictions on coordinated advocacy with that organization violated the First Amendment. The opinion does not strike down the relevant provision of the President's 2001 executive order that established the Frozen Assets Program, but it does reveal some real chinks in the armor insofar as it regulates domestic organizations. The target of the freeze was a nonprofit organization incorporated in Oregon called the Al-Haramain Islamic Foundation, Oregon, or AHIF Oregon. In early 2004, the Office of Foreign Assets Control froze the target's assets without obtaining a warrant, pending an investigation concerning the potential designation of AHIF Oregon as a, quote, specially designated global terrorist, close quote, pursuant to an executive order issued by President Bush in the wake of the 9/11 attacks. Later in 2004, after the investigation had concluded, AHIF Oregon was formally designated under the executive order and its assets were permanently blocked. After seeking administrative reconsideration for several years, AHIF Oregon finally filed an action in court in 2007, challenging the designation on the merits and asserting a variety of statutory and constitutional procedural objections. The Ninth Circuit ultimately concluded that there was sufficient evidence to conclude that AHIF Oregon was properly designated because of its ties it had to a related organization, AHIF Saudi Arabia, which had connections to recognized terrorist organizations. Although the Ninth Circuit rejected most of the plaintiff's challenges procedurally, it did hold that the freeze of assets without a warrant violated the Fourth Amendment. The legal question was primarily whether the blocking order fell into the special needs exception to the Fourth Amendment, such that a warrant prior to a search or seizure was not necessary. As a general matter, the special needs exception may apply where a search or seizure is conducted for important non-law enforcement purposes in contexts where adherence to the warrant and probable cause requirement would be impracticable. There was no question but that the seizure was conducted for important non-law enforcement purposes, but the Ninth Circuit did not agree with the government's assertion that requiring a warrant and probable cause was impracticable. The court did agree that a properly limited blocking order could initially be imposed without notice or a warrant because of the risk of asset flight under the emergency exception to the warrant requirement. But the government could not explain why, in this particular case, a warrant could not have been obtained within a brief amount of time after the emergency blocking order went into effect. And absent that showing, the Ninth Circuit held that in this particular case, the failure to obtain a warrant violated the Fourth Amendment. At this stage of the litigation, it is not clear what relief might be appropriate, if any, so the Ninth Circuit remanded for consideration of possible relief for the Fourth Amendment violation. The executive order also prohibits any person from making, quote, any contribution of services to or for the benefit of, close quote, designated entities. We had in this case a co-plaintiff nonprofit, which was not a designated entity, which sought to have this portion of the executive order declared unconstitutional as applied to it, so that it could coordinate with AHIF Oregon at press release and press conferences to advocate on behalf of AHIF Oregon. On this aspect of the case, the court found the executive order restricted speech based on its content, so that strict scrutiny applied. The court found in favor of the plaintiffs on this claim, concluding that the government's asserted interests were rather remote and weak, particularly since it was clear that the co-plaintiff had a First Amendment right to independently advocate for AHIF Oregon. Now, the Ninth Circuit's decision here was very carefully crafted. It was not written as a broad attack on the constitutionality of the executive order. Instead, the court closely examined the government's asserted interests in light of the particular organization and facts before it. Nevertheless, the opinion does lay out a roadmap for other domestic organizations, which have been targeted as terrorist entities, to successfully challenge the constitutionality of one part of the war on terror. And in that sense, it is, I think, a significant loss for the government. And now we have three one-liners. First, in the area of sentencing. In United States v. Fitch, the defendant was convicted of bank fraud, fraudulent use of an access device, and money laundering. The sentencing guidelines for these crimes was about 4 years. But at the sentencing hearing, the judge found by clear and convincing evidence that the defendant had murdered his wife and that her death was the means he used to commit the fraud. Based on that finding, he imposed a sentence of 21 years. Defendant appealed, arguing that the upward adjustment violated both statutory and constitutional procedural protections. Well, the Ninth Circuit affirmed the sentence, noting that the sentencing judge has always had, and still maintains today, broad discretion to increase a defendant's sentence based on uncharged conduct, so long as the sentence does not exceed the statutory maximum, which in this case was 36 years. As the court noted, such increases based on uncharged conduct do not punish a defendant for crimes of which he was not convicted, but rather increase a sentence because of the manner in which the defendant committed the crime of conviction. It's a fine distinction, and one the defendant may not really appreciate, but it was sufficient for the court to affirm the lengthy sentence. Next, we deal with a question arising under Indian law. In Confederated Tribes and Bands of the Yakima Indian Nation versus Gregoire, the Ninth Circuit upheld an excise tax on an Indian tribe's sale of cigarettes to non-Indians. While it is the law that states lack authority to tax Indian tribes or registered members of Indian tribal organizations absent a clear authorization from Congress, the burden of the excise tax imposed by the state of Washington on tribal sales of cigarettes to non-Indians does not fall on the tribes. It falls on the purchasers. The court noted that the pre-collection obligation placed on the tribes is a minimal burden and does not change the legal incidence of the tax. Accordingly, the state may legally impose the excise tax. Finally, in the area of remedies, in Gonzalez versus Arrow Financial Services, a split panel of the Ninth Circuit held that a debt collection agency was liable in a class action for statutory damages under both the Fair Debt Collection Practices Act and California's Rosenthal Fair Debt Collection Practices Act. The Rosenthal Act had been amended in 1999 to bring it into conformity with the Federal Act by explicitly providing that every debt collector shall comply with and be subject to the remedies provided by the Federal Act. Given this amendment, the court held that a class action, which is expressly permitted by the Federal Act, was now available under California state law as well, and that statutory damages could be awarded twice, once under the Federal Act and once under the state law. The dissent argued that awarding statutory damages under both federal and state law was duplicative, since the state law simply incorporated by reference the federal remedial provisions. Well, the majority, I think, seems to have the better of this argument, at least by the text of the statute. While it does seem to be a duplicative recovery to have statutory damages awarded under both federal and state law, the language of the federal and state statutes seems to provide for precisely that result. Well, that's it for today's Kelso Report. Have a great day in the law.